Well, hello. Thanks for joining to think about some important special ed law topics. Wish I was seeing you all in person, but still a great chance that we have to interact and think through some of those key issues out there for us in special ed law to go back and think through and work through. And my session for you all this fall, trying to go back to the basics here a little bit. We've been playing catch up over and over and over again on so many of the legal issues that are out there for us that relate to the pandemic and COVID and new legislation. And I think sometimes it's good to go back to some of those basic frameworks of the IDEA and have some good reminders of what the law has to say and how that's been litigated in recent years to really be thinking about what we need to be considering as IEP teams are making good decisions, and particularly placement decisions. And so I'm going to talk with you today about issues related to inclusion, least restrictive environment, and understanding really where the law is and what factors we need to be thinking about as an IEP team as we walk through those issues. So thanks for doing that, and hopefully we've got some good information to share. And so the first step I want to think through in this issue is to go back and think about some of those basic legal frameworks that undergird the least restrictive environment framework. We need to go back and recognize really what those requirements are, and then we can build upon that as we see how that plays out in a variety of ways. And ultimately, under the IDEA regs, where it requires a school district to the maximum extent appropriate, make sure that children with disabilities are educated with their non-disabled peers. And that when we're moving a student with a disability to a more restrictive setting, then we can do that only when, we get to that point where education in the regular classes with use of supplementary aids and services can't be achieved satisfactorily. And that really comes back to looking at the kinds of factors we need to be thinking about when we're talking about a change of placement. And so, these are the regs that, continue to be interpreted by courts and hearing officers over time. And we need to come back and think about what they really mean for us in real life. Now, for those of us in the Seventh Circuit, we've got kind of a different approach than might be in other places around the country. Other circuit courts have created some multi-pronged tests for LRE decisions. In the Seventh Circuit, they haven't really done that. They've said really the basic statutory framework is the right framework. And that really comes from the Seventh Circuit decision way back now, almost 20 years ago in Bethby versus Van Clay. And this was a situation where a school had recommended placing a student in special ed with a few, the court called reverse mainstreaming opportunities, or the ability to have some integration with non-disabled peers, and they found that was FAPE in the least restrictive environment. The student was only in the regular class for about half the day. Her academic and developmental progress had been limited, didn't receive satisfactory education in the regular classroom, and so they found that this placement was the least restrictive environment. And in making that decision, and of course, back in 2002, we were still talking about the Rowley standard instead of NJREF, but we really want to talk about that FAPE standard, right? Whatever that FAPE standard is. That time it was Rowley, today it'd be NJREF. But here, the Seventh Circuit really put those two, the idea of FAPE and the idea of LRE together. And what I think was important in this case is that the student's parents were arguing that if the student got any benefit whatsoever, was receiving some educational benefit from being in the regular ed setting, then you couldn't remove her from that setting. But the court said that's not really how FAPE is supposed to work. And the court said by applying that FAPE standard to the LRE directive and arguing that the school district can't remove Beth from the regular classroom if she receives any benefit there, then Beth's parents turned the FAPE standard on its head. Instead of granting flexibility to educators and school officials, it places an extreme restriction on their policymaking authority and the deference they are owed, and vitiates school district's authority to place any disabled children in separate special education environments. The court said neither Congress nor the Supreme Court intended that result. And so this is where the Seventh Circuit, instead of identifying sort of a multi-factored, multi-pronged test like some of the other circuits have adopted, the Seventh Circuit said, we're not going to adopt a formal test, right? Because each student's educational situation is unique. Ultimately, they said, if Beth's education at Lake Bluff Middle School was satisfactory, then the school district would be in violation of the act by removing her. And if not, if its recommended placement would mainstream her to the maximum extent appropriate, no violation occurs. And again, in this case, they found no violation because she wasn't able to receive FAPE in that less restrictive setting of those placements that were being considered. And then we see, the Seventh Circuit, continuing to answer this question the same way. A few years later, in the Ross case in 2007, similar argument was made by the parents that as long as the student was receiving some benefit, that she had to be kept in the mainstream. Here the court asked whether that education be satisfactory, and if not, whether reasonable measures would have made it so. And here the court again agreed with the school district that removing the student from the mainstream environment was appropriate, after they had attempted to serve the student in good faith, complied with the law, and making that change in placement. So showing that they had tried ahead of time before moving to that more restrictive placement. And I think that's where we see so many of these cases coming back to, is that piece we mentioned earlier in the regulations. If disability in the regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. And so many of these cases come back and look at, were there appropriate supplementary aids and services attempted in these situations? And did they make the education satisfactory? Was it enough to still be FAPE and still be appropriate? And I think that's the careful balancing act that we look at when we work through those decisions. So, that's really that starting framework for us when we're talking about, the legal analysis we're going to apply in Illinois. So let's dig deeper and really look at some of those issues of inclusion and least restrictive environment and how they've played out in various places. And I think something that really stands out to me, and again, I'm quoting here from a hearing officer decision from 1997, so certainly not a recent case, but I think it speaks to these issues. And again, we're kind of going back to the basics here and figuring out where courts and hearing officers have been historically and where we're at today on this. And one of the things that stands out to me about this Rochester, New York hearing officer decision from, now 25 years ago nearly, is looking at that difference between these terms that we use, least restrictive environment, inclusion, mainstreaming, and again, generally those are used interchangeably, but, we also recognize that at least one hearing officer over time has tried to look at those subtle differences. And I think we need to make sure that we're using precise terms here. In this case, that hearing officer said, inclusion generally means placement with their age appropriate peers. And they're receiving the appropriate special ed services, working towards their goals, which is different from mainstreaming, which is in the regular class with the same expectations, curricular expectations as those peers. And I don't know that we always make that distinction here, but as we walk through some of these other cases that we're going to talk about, I do think it is important that we recognize the various layers that come into play when we're making those LRE discussions. Also recognizing that this encompasses not just the academic setting, but non-academic and extracurricular activities as part of that decision-making process as well. So when we're thinking about inclusion, we've got to think about all the ways to make sure that students with disabilities can be included with their non-disabled peers. Now, again, as I said earlier, the Seventh Circuit hasn't adopted a formal multi-pronged test like some of the other circuit courts have, including the Sixth Circuit. But I do think the Sixth Circuit decision from 2018 is an interesting one, because it again goes back to that issue of, the relationship between FAPE and LRE. And I think what makes this case interesting is that this is one of the first times we had a appellate court addressing that issue head on after Andrew F. And once we saw that new FAPE standard. But again, the court is saying we've got to be careful, about equating those in ways that don't make practical sense. And said that, placement in the LRE and the appropriateness of the IEP are two separate analyses, linked but separate, right? The court said the appropriate yardstick is whether the child with appropriate supplemental aids and services can make progress towards the IEP goals in the general ed setting. And in this case, they found that the school district, this case comes from Tennessee, violated the requirements of NJREF, meaning did not provide FAPE by removing the student from the general ed setting based solely on his difficulties with the curriculum, recognizing that you can have an appropriate plan, but still be implemented in a less restrictive setting. And we've got to make sure that those are two separate inquiries. Again, they're linked, but they're still separate. And as we think about, providing that continuum of placement options, the regulations require that we have to have that full continuum available. That's why so many of us are members of special ed cooperatives and use other programs, private programs, to make sure that we are meeting that full continuum, so that we are looking at how we can meet needs in a place that it maximizes that time with non-disabled peers. But I think an important nuance in that discussion comes back to the regulations, the federal regulations, making it clear that, again, inclusion in regular classes is not the same as participation in the general curriculum. And that specifically the regulations say that a child with a disability shouldn't be removed from the education within age-appropriate regular classrooms just because they need modifications to the general curriculum, right? That we may have to sometimes make those modifications to the general curriculum in the regular ed setting. Again, distinguishing and having separate analyses for what are the appropriate services and where can we deliver those services appropriately. And that when we are talking about students who need adapted or modified curriculum, that still can be done in a less restrictive setting and still can be done in the gen ed setting. And those are, again, individualized, unique decisions made on a case-by-case basis. And so as we are thinking through and planning for those decisions, we need to recognize that those are not one and the same. And again, looking at where OSEP has given us guidance on that, that we still have to make individual decisions and that we can't remove a student from the general ed environment merely because they require modifications to the curriculum. We have to first think about how we can adapt that curriculum in the gen ed setting, and then start moving out from there to where we might need special education placement or services. I think that is really important for it. And one of the ways that courts have affirmed that as a possibility are cases like this one that looked at issues like parallel instruction. And again, parallel instruction is not appropriate for every student, but as we're thinking about that continuum of placement options, one of those options we might consider as to whether it's appropriate would be something like parallel instruction, meaning a student is within the regular classroom, but are working on an entirely different separate set of tasks alongside the non-disabled peers. This case from Michigan, affirmed by the Sixth Circuit, again, an older case, but going back to some of those basic building blocks of this inclusion analysis, where a student was in regular ed, science, and social studies and other classes. And while they were working on things that were very different from their peers during that class, it was still appropriate based on their IEP goals and their ability to have that socialization and other piece with peers. So we recognize the balancing of the academic needs with the other educational needs that a student might have. And of course, we can only make that consideration of moving to a more restricted placement after we have tried appropriate supplementary aids and services to make that placement successful. Now, I think that there's no sort of magic number of attempts. I also think that courts and hearing officers are not going to require us to try something we know has a very low or zero chance of success before making a placement decision. But generally speaking, if something is reasonable, we need to show that we have tried to make that less restrictive setting work before we're talking about a move to a more restrictive setting. And that certainly can include, on the academic side, those curricular or other modifications and accommodations. And then we'll talk about behavior in a little bit with a little bit more detail. But I think those are important considerations for us to keep in mind for sure. And again, when we're making those decisions, we've got to make sure we are well documenting the placement decision. Why did we place the student in this particular place on the LRE continuum? It's got to be that individualized determination. And I think sometimes we start to think too categorically, right? Well, this student has this disability, so here's how we serve those kinds of kids. And this student has this disability, and here's how we serve those kinds of kids. Or we're going to make this placement available, and so we're going to put the same boilerplate statement in the IEP that we had put for everybody else. And that's got to be, something we are really considering on a much more individualized basis. Looking at this OCR decision from 2016, where 81 different IEPs for 81 different students had boilerplate, same language as to why they made a placement decision. OCR said, that doesn't sound like an individualized determination to us. So how do we come back and make sure that the decisions that we're making are in fact individualized based on the unique needs of this student, and that we're documenting it that way? And again, we're talking about the maximum extent appropriate. And so this is the idea that there's going to have to be some decision by the IEP team that this is an appropriate placement to attempt, that it's reasonable to do so, not just because we're going step by step by step by step. To try something that nobody believes has a chance of success wouldn't be appropriate, only if we think that it does have that chance for success. And then I think we have to recognize that there is clearly a non-academic component to this as well. And this is where I think we come back into some of those more 504 or disability discrimination like considerations about inclusion that start to go outside the classroom to make sure that our policies and our practices for accommodating students in other ways don't have the effect of segregating them based upon disability, or preventing them from having access to or participating with non-disabled peers. This case from Virginia was a student who had a food allergy who was required to always sit by himself at lunch. And OCR was like, hey, there were ways to make sure the student could eat lunch with peers and socialize with peers at lunch, while also accommodating disability, like having an allergen-free lunch table where peers could come and choose to sit with him and those types of things. And so looking for ways to encourage those opportunities for inclusion certainly are there as well, for us to keep in mind. So, I think that as we start to take this conversation about some of those basic premises of inclusion and apply them in more practical ways, we've got to stop and think about behavior, because and I know that is the most frequently litigated issue when it comes to changes of placement. It's probably the most frequent genesis of placement change conversations. Let's be honest. I'll get lots of phone calls that say, hey, Brandon, we want to talk about changing placement for this kid because their math computation skills are just not where we want them to be, right? I don't get that phone call the same way I do when it's about behavior, right? Behavior is what gets us moving, because that is harder to understand. It's harder to manage. It's harder to just sort of let it go, right? And so we recognize that these same approaches and these same legal principles also apply in that context of behavior. And so when we're thinking about those behavioral issues that are there, we've also got to come back to make sure, have we put in place those appropriate behavioral supports and strategies and positive interventions before talking about a more restrictive placement. And we've got some key cases out there over time that I think have really developed where that lands. When we start talking about this Second Circuit decision from 2014, this is where you really start to see these cases start to take a different trajectory. Early on in my career, a lot of the behavior cases, if you had a behavior intervention plan, courts and hearing officers weren't really digging too much into the details of that. But we've really started to see that change over the last decade or so. And I think cases like this Second Circuit case really laid some of that early groundwork, where the failure to have that BIP here was a FAPE issue. And in fact, part of that was based on the fact that even though there wasn't technically a requirement for an FBA to be conducted in this case, because there wasn't a suspension or manifestation termination, the lack of an FBA still led to an appropriate behavior intervention plan. Similarly, this case from Michigan in 2015, one of those cases that stands out to me because what the court ordered was that the school provide a full-time one-on-one licensed psychologist for this student, because they failed to first on the front end conduct an appropriate FBA before looking to change placement. This was a student who had some pretty significant behaviors. If you go back and read this full case, you will see that those behaviors are oftentimes very significant, very violent. They were not small episodes. They didn't happen very often, but when they happened, they were of high intensity. And so the district was looking to change placement because of those behaviors, but they came back and said, hey, you didn't really try appropriate supplementary aids and services in the less restrictive setting first. And the reason for that is because you never really conducted the right FBA in the first place. So I think that's really important. And of course, InjuRef itself. We all hopefully are familiar with the 2017 Supreme Court decision. But remember that 2017 Supreme Court decision wasn't the end of that case, because really what the Supreme Court said was wrong standard, go back and do it over again. So the Supreme Court didn't end that case, it started it over again. So then that case restarted back in the federal district court in Colorado to redecide whether or not the school district's proposed plans, IEPs, were in fact FAPE. And for the first time in that litigation, because of the Supreme Court's changing FAPE standard, the lower court said it wasn't. And interestingly enough, what was it? It was behavior. Right? It came back to the lack of an appropriate behavioral intervention plan in that case as well. So that's where I think when we're looking to make these changes because of behavior, I think there's three things we need to make sure that we are carefully documenting as part of that placement decision. One, documenting why the current placement is working. Be specific about it. What is it that isn't working? But I think we have to go beyond the what to the why. Can we explain why? I think to be persuasive to parents or to hearing officers or courts, we need to show that we understand why these problems are occurring, why the behavior is having an impact. And so we need to be careful to make it look like we just want to move the kid someplace else, that we're not trying to accommodate, that we're not trying those supplementary aids and services to make the current placement satisfactory, to make it work. And I think one of the ways we have to be able to show it is not just what isn't working, but that we understand why it isn't working. I think that's fundamental to making a good placement decision. And then, of course, document that carefully in the meeting notes in the IEP. The second thing I think we need to do is to make sure that we really have tried to make the less restrictive setting work. Have we fully implemented an appropriate behavior intervention plan, looking at data based on a good FBA? Have we demonstrated fundamental patience in our approach to that situation? We aren't jumping too quickly to a change in placement. We're not reacting to a single occurrence. We're looking at behavior over time so that we can show that we really have tried to make those other supplementary aids and services work. And when we're talking about behavior, usually that means the behavior intervention plan and related positive interventions based upon a good FBA. Those are factors that are really there for us. And then third, in these behavior-related placement cases, we need to explain why the proposed placement is going to be appropriate. It just can't be just because it's someplace else, right? As InjuRef said, we have to have a cogent and responsive explanation for our IEP team decisions. And we need to be able to have that cogent and responsive explanation as to why it is reasonable for the parent, for the IEP team, for the hearing officer to conclude that this proposed placement is more likely to be satisfactory. What is it about it, right? And help the parent, help the hearing officer understand and document that we're doing this for the student, not to the student, right? That this change in placement is not about punishing the student. It's not about removing the student so much as it is about putting them someplace where they can succeed, right? That the purpose for this change of placement is this student's progress, right? Not simply because we don't know what else to do with it. That's what we've got a solution. Here's our solution, and help the parent and if necessary, the hearing officer buy into that solution. And of course, document that carefully in the notes. And so I just think those types of things that pop up for behavior, certainly I think we start talking about BIPs and FBAs, that's a whole other conversation. That's a whole other training to be thinking about. but they are clearly relevant to that inclusion piece. Because when we look by and large, a lot of times those kiddos with behaviors are what get them out of the mainstream and have less opportunities for inclusion. And we need to make sure that we are managing behavior in a way that isn't limiting those opportunities, because we're providing FAPE in the LRE. And so I think those unique pieces that are behavior related are certainly there, but they also apply more broadly as well. So let's think about what we've talked about up to this point on inclusion, and start to put that into some more practical considerations. And I think that one of the things that are out there for us from that practical perspective is, again, making sure that we are clearly documenting our rationale. We need to make sure that we have looked at the continuum of options we've considered, why less restrictive options were rejected. We got to clearly, appropriately state that cogent and responsive explanation. Again, whether that's a behavior case or an academic case or whatever the reason is, that we're looking at more special ed time, less opportunities for inclusion for a student. We need to make sure that we've got clear, consistent, individualized, not one size fits all answers for that. That shows that we have taken the letter of the law and the spirit of the law to heart in making that decision, and that we've appropriately done that. And that's where over time, I think we're getting better at this, because we have more flexibility in the very practical reality of the form we fill out. Sometimes in the past, before the days of electronic IEPs, and before the days of the magic of things like you could write as much in a box as you want, and the box is just going to get bigger. Back when we used to have just tiny little boxes to put information in, sometimes we had vague generic statements that weren't really appropriately stated. And then I think that created bad habits for us, because once we did then have the actual ability physically through the software we're using, to have more space to write, we got so used to writing just a little bit that we didn't take advantage of that opportunity. So we want to make sure that when we're talking about placement decisions, that we are really talking about not just what we decided, but also the other options that were considered. That's part of prior written notice, right? So make sure that we are doing that. And again, when we talk about appropriately making and documenting those decisions, they've got to be based upon the student's needs, right? Not on other factors. Like, it can't be based simply on the category of disability or the severity or even the availability of services, right? Or the availability of space or administrative convenience. We can't use those as excuses to not serve a student in the least restrictive environment. And so I think it is really important for us to keep that in mind, and that we aren't defaulting to these types of factors that the Department of Education told us are not appropriate considerations for LRE decisions. Just to also look at some of these cases that I think we can learn some practical lessons from. This case from New York, always is one that stands out to me. We're going to see a couple other cases that have similar things. This is a student. The district proposed placing the student in a 1-to-1+1 program, which meant the entirety of the student's day was the student to a teacher and a para. So 2 adults, 1 student, 100% of the time. Parents said, we're not sure that's the least restrictive environment. And the hearing officer here, the court, said, we're not sure either, and here's why. This student had IEP goals for socialization with peers. And so the court's sort of going, how do we work on IEP goals for socialization with peers when we don't have any peers? So, recognizing that goals have to drive placement, not the other way around. And so this was found not to be the LRE because it didn't allow the student to actually work on their IEP goals. Very similar case this year, 2021 case from Knox County, Tennessee, where the court said that the fact the student needed some more intensive supports didn't justify the proposal to place the student in special ed for the more than 2/3 of the school day. And again, the court looked at this and said 2 of the child's IEP goals were aimed at developing socialization and communication skills, which according to the expert testimony require interaction with non-disabled peers. And so here they said, we don't think that spending 2/3 of the day in the special ed environment is the LRE when those are the goals for the student. And I think we've got to, recognize, both pieces to that. The goals have to drive where we're going. And if we're saying these are the skills the student needs to work on, then we've got to find a way to do that. The fact that it's hard or more difficult, takes more work for the student to be in this gen ed classroom for more of the day, that's maybe true, but it's not a legal basis for excluding them and not providing that opportunity for the interaction with non-disabled peers. One of the other factors that I think stood out about this case for me is the school kind of basically made the argument. My short version of it is our special ed time is going to be able to allow him to do more. He's going to get more benefit from his time in the special ed class than he would from his time in general ed. And the court was like, well, okay, but you still have to be able to have the opportunity to work on those goals. And so the fact that it's, FAPE isn't about the best, FAPE is about appropriate. And so here the court kind of came back and looked at what's appropriate while still in the LRE. And so coming back to that piece that we've talked about time and again, right? What supplementary aids and services can we put in place in that least restrictive environment situation to make that work? And if we haven't really documented well and attempted those additional supplementary aids and services, then we got to see where we're at with that. So what factors, right, might be relevant? So we look at, where courts and hearing officers have been over time. The factors that are relevant to decide whether a placement is in fact satisfactory. One is if the student would not receive sufficient educational benefit in a regular classroom, even with those aids, right? And I think especially post-INJUREF, that means that if a child is unable to make appropriate progress in light of individual circumstances, then that's a factor, right? And so obviously if a student can't receive FAPE, right, they can't make the appropriate progress, then I think that that's certainly a factor that we want to keep in mind. Another factor that's been held relevant is if the student's need for those intensive special ed services outweighs the need to interact with peers. But again, beware here, because I think there's a trap here of failing to consider whether or not those services could also be provided in a less restrictive setting. And so, really recognize that, special ed is anything but one size fits all. And when we say, well, we would only provide service X in placement Y, we've tied our hands in ways that may not allow us to fully implement in the least restrictive environment. So making sure that we're not, pre-deciding the one and only way that services could be delivered. And so I think that is important for us. Another factor is if the student has significantly disruptive behavior that interferes with the education of classmates. Now, when we talk about the effect the student has on others, courts have been really hesitant to say this should be a determinant factor. This could be a factor considered among others, but if this is the determining factor, courts are not likely to go there, right? They don't like making a decision on that basis. They want to see other reasons that are there. And so certainly I think when I look at the case law, the effect that this student has on others is relevant, but I want to be cautious about making that a determinant factor or a primary factor that we're relying on and arguing or making or documenting that change in placement. The next factor that we see relevant sometimes from courts and hearing officers is if the student will require so much modification in the curriculum that the regular program has been altered beyond recognition, and it results in limited educational value to the student. But again, still pay attention to that requirement to maximize the time with non-disabled peers. So there's still a balancing act that we have to consider, even when we look at a student who needs really significant levels of modification to the curriculum. So coming back to just some of those basic rules, right, when it comes to those placement decisions. One, we're never going to predetermine placement. As part of that, we're not going to have those placement pages fully completed ahead of time. And I know with our drafts, We look at what the school code says, we don't have to include the placement and services page as part of the draft. I think that's important. We need to know what we're going to recommend, but we don't want to be seen to be predetermining that placement, that we want to have that discussion about goals and other things first. Rule number 3, I know this is hard because it starts to get outside our own level of responsibility or control. But when we're making placement decisions based on the schedule, right? When we go back and think about, that statement from the Department of Ed that we can't base, placement decisions and LRE decisions on administrative convenience and the availability of resources. It's got to be based on the student's needs, right? So just be cautious about being unwilling to be creative with our school schedule to meet the unique needs of an individual student with a disability. And then finally, number 4 here, remember, goals first, then accommodations, then placement. That's the order in which we have to decide it. Sometimes when we start talking about moving a student to another placement, then we say, oh, well, am I writing goals for this placement or the placement we're going to propose? That's not how it works. We write goals for the student. Then we decide where and how we can implement it. Right? And we want to just be really cautious about it, because I still see a lot of special educators having that discussion in a way that starts to sound like they write goals based on the placement. Like if we're in this behavior placement, then we're going to have this sort of predetermined set of goals. Or if we're in this self-contained classroom, these are going to be the goals we have because that's what the goals of the students in my classroom have. No, right? No. What does this student need? And then where and how can we deliver it, right? Goals drive placement, not the other way around. So again, we want to look at all goals and objectives when we're looking at those services. We've got to have that link, right, between present levels and the goals and the placement and services we're providing. And we've got to make sure that they are based upon that individual determination of where and how those services can be provided. And so when we're looking at some of those additional factors, right, how do we maximize that interaction with peers? How do we maximize that continuum that is not going to segregate or separate or isolate the student? How do we meet needs through supplementary aids and services and accommodations, right? So that we can accommodate in the gen ed setting to the maximum extent appropriate. Can we look at that type of services, direct, indirect, individual, group? How do we, again, maximize that peer interaction piece? Do we have other inclusive practices like co-teaching and other factors that can allow that student to receive those services in the general ed environment? And again, if we can't do that satisfactorily, then we've got to discuss the reasons why and have we addressed those? Because I think that's also kind of an interesting place to work backwards. Like, if we say, this student needs a special ed placement because reasons 1, 2, and 3. Well, I would hope that there's documentation to show that those 3 reasons were considered to say, was there a way to accommodate that in a less restrictive setting first? And I think that's the right way to structure that conversation, but also a really important way to document that conversation in the IEP and what I would expect and want to see in the IEP notes as well. Again, it's got to be that explanation of why, right? The IEP document has to inform the parents why the placement decision was made, not just what it was. Okay? That's part of meeting our prior written notice requirements, is to make sure that we are actually providing reasons why, supportive documentation, other options considered. That's how we make sure that we are meeting our LRE mandate as well as our prior written notice mandate as well. So, beyond the IEP team decision, I think inclusion takes us to broader, bigger picture conversations about how we serve students with disabilities. And that requires a school district community as a team to believe in the success of inclusion, right? It's not just about what the special educators do what we write on the IEP, right? It's what everybody else does. It's what the general educators do, what the administrators do, how we are preparing the school environment, and how we are fostering a culture in our school environment to make sure that inclusion is something that we value, that will be successful. I think that's really important for us. And so how do we create that culture in our building? You know, one of the ways we can do that is to incorporate more UDL, you know, Universal Design for Learning practices. The more of that that's in place, the more that our school culture and the environment is already set up to respect, understand, and actually live in, you know, an inclusive mindset, so that we are not always looking for how do we, you know, separate special ed students and serve them. It's how do we treat them like everybody else, right? How do we get those inclusive practices there? And so finding things like UDL, I think, is really important for us. But ultimately, I think it comes back to a culture issue. You know, inclusion is not just a place. It's not just how we fill out a form, right? It's the mindset that we have as a school district, as a school building, how we approach kids, right? So that we think of all students as students first, right? I think that historically, we've tried to categorize students. I think sometimes because of all the data and testing and everything else we have to do, you know, we really do try and put students into their categories and their boxes and their, like, what column do they fit in and what row do they fit in. But kids are kids. And whether they have a disability or not, you know, we need to be thinking about how we make the school environment inclusive for them. And I think that is a mindset that goes beyond, again, how we fill out the IEP form. It's making sure that every teacher is empowered to understand how to accommodate and serve kids with disabilities, that every teacher is communicating that mindset, not only with what they say, but with what they do. And I think if that is the mindset that we're having, then it is going to be natural for us to then use that approach and factor that in to all of the decisions and discussions that we have when it comes to least restrictive environment. And so I really encourage us to make sure that we are going beyond simply filling out forms the right way. That's a big first step, right? As a school lawyer, getting everything documented, making the right IEP team decision that's defensible and legal. I'm there with you, right? But I do think that in order for that to be successful, for that to have the intent that the IDEA has for kids, you know, I think it means that we've made that something that we value as a school district and as a school building. And I want to make sure that was one of the things that I think caused me to want to come back and talk on this topic, right? Because I think that it's such a basic, foundational, fundamental principle of the IDEA, and we get so caught up in the details of the new things that it's a good practice for us to sometimes go back and immerse ourselves in those very basic principles, so that, you know, when we're having those conversations with parents, when we're working on those conversations with staff through an evaluation process or just good coaching in the building, when we're looking at who we want to hire, when we're thinking about our professional development and what resources we need to have for folks, let's, you know, there's always the new shiny thing, right? But sometimes we need that chance to go back and don't assume that newer staff, that newer teachers have automatically learned those lessons, right? These are lessons we all have to learn and come to know. And so I think it is important for us to recognize the role that we all have. And so because it's not a new topic, certainly doesn't mean it's not an important topic. It's absolutely one of the most important topics in special education. It's one of the most important topics in litigation and special education. And I want to make sure that it's part of our mindset, of our culture, of our professional responsibilities, of our professional development. I think that's really important for us because we want to be making those good decisions when it comes to inclusion. So thanks for hanging out with me for this time. Hopefully I'll see you all in person sooner rather than later. But appreciate the chance to be able to talk to you all here, at least virtually, this fall, and certainly on such an important topic. So hang in there. You all are all doing great things for kids. This has been a heck of a year, and we're going to get through it and get back to those things, but maybe having a conversation about some of those big picture principles here, like inclusion, help us get back. So again, thanks for all you do. Thanks for spending time with me today. And I hope you all have a great rest of your school year. Take care.